Hi, I'm Greg Dell here with attorney Cesar Gavidia, and Cesar just came across a case decided October 2018 against what was Paul Revere, which is now Unum Disability Insurance Company, the world's largest disability insurance company. It was a private disability policy for a financial planner. And it made me want to talk about the issue of factual versus legal disability, which is something that we often see for the many financial planners and physicians that we've represented, and real estate agents, and lawyers that have occupations that require a license to practice.
Right.
So let's talk a little bit about this scenario, because we probably get this call at least once a week from some kind of professional that's been having a medical issue, and subsequently, because of that medical issue, they end up potentially committing a crime or not being fit to practice and lose their license, and what subsequent impact that has on their ability to collect disability. So let's start first, like, what are the typical medical conditions you see that result in someone not being able to practice?
So the ones we see most often are the anxiety and depression claims, mental health claims, and usually which you could kind of categorize into that are chemical dependency claims, drug abuse claims, alcohol abuse claims, those types of claims that kind of overall are in the spectrum of psychological or mental health issues.
Yeah, and I think it's important to note that first, usually resulting in a loss of license or resulting in issue is that they have the substance abuse, which can be, like you said, drugs,
the precipitating
chemical,
cause
alcohol.
too. Yeah.
As a result of that, they'd end up having secondary depression or anxiety. And what happens is often we see these professionals continue to work in that capacity of having the abuse disorder, and then eventually what I call an event happens, a disaster. Something to the point where a doctor has a bad event in the hospital, God forbid injures a patient or something like that. A financial planner starts to commit inappropriate acts, whether they're stealing from a client or engaging in acts of fraud, not doing things that they told the client they were going to do because they're not cognitively able to do their job because of the abuse. So, and what's the pattern you usually see between the condition they have and when they end up deciding to file a claim?
Well, usually you see a certain pattern of things happening with them. Their symptoms are increasing, they're worsening, it's kind of the spiraling effect. Their home life starts kind of, falling apart. They may be going through divorce or something like that. Their life just starts to crumble slowly. It may start in their career or at work, or may start at home, but usually you don't see the treatment start up right away. It's after so long when things kind of have hit a point where it's difficult to turn back, certainly almost impossible to function in their profession, that they start seeking treatment. And this is one of the issues, because we get calls very often from financial planners, like you said, lawyers, doctors, that they haven't seen a doctor yet. And they've been having these issues for years. They've been, they're divorced now. All of these things have kind of come about as a result of their mental health issues that have completely gone untreated, to the point where I even had one client who didn't even realize, I could say he probably realized it, but was in a state of denial over his, mental health issues. And I convinced him he needed to go see a doctor. And that's what he's doing now over that. And he thought all along it was some issue related to physical problems he was having. But at the core, when someone calls you and they're weeping or they're crying, you know that there's something really deeper there that needs to be treated.
Well, the biggest challenge that many of these claimants face is that, so let's say the financial broker who gets a FINRA investigation or an SEC investigation or an indictment, and then they call us the next day and be like, I can't work, I got indicted, I have a disability policy. And then we'll be like, okay, was something wrong with you?
Right.
And then some of them will just say, no, I'm just a fraud. And we go, okay, obviously we can't help you.
Right.
But the other ones will say, well, yeah, I had a severe alcohol problem, or I had a pill addiction, and I wasn't really aware of what I was doing.
Right.
And so then the next question is, well, were you treating with a doctor?
Yep.
And the biggest challenge we face, and we've been able to help clients in this situation, is that many of them say, no, I wasn't seeing anybody. So then the question becomes, we know what the disability company is going to say is, well, you weren't treating with anyone before that date of disability, and now your license became in jeopardy because you got indicted or you had an investigation. So our position as a disability company is that you're legally disabled because you couldn't practice because you had this indictment or whatever, and you don't have a factual disability because you don't have the support. So where's the law in terms of, and maybe clarify, a factual disability versus a legal disability?
Just to be clear, so factual disability under the law is defined basically as an illness or injury that leads to the disability, that causes the disability. A legal disability is when something involving the law or a license revocation causes the disability. So when there's a license revocation or an incarceration or something like that, or even a disciplinary investigation by a board, okay, that controls the licensing, the insurance company is going to immediately hone in on that. Flags are going off, okay? They're going to investigate that to its core. And we've had claims successful claims when we were able to get approved despite those issues going on. But that's why it's so important to establish medically, through the medical records, through the treating doctors, that this person has these symptoms, that these symptoms have led to their disability, their inability to perform the occupational duties of their profession, of their occupation. And it's not this licensing issue. You really have to kind of get an understanding person on the other side. Because in most cases, the disability insurer is just going to kind of, I don't want to use the word exploit, but they're certainly going to take advantage of the fact that there is some other cause here. And they're going to be very skeptical over the reasons of the, involving the disability claim.
But at the same time, the disability companies kind of understand that you have a doctor who's practicing for 20 years and all of a sudden gets addicted to
Propanol.
Fentanyl or something like that. And then doesn't have any treatment but loses his license because he's high, doing surgeries, and then he was normal for 15 years. All of a sudden he had a problem, and then he starts to get treatment after he was caught in what happened. The hospital suspended him. The medical board's investigating him. So even though he didn't have treatment before, if that person were to engage in treatment immediately thereafter, being basically called out, because that's what happens to someone, they don't really accept the problem until they unfortunately have an event, that person can still make the argument, that's what we would have to do as lawyers, that he was factually disabled before he became legally disabled.
Right. And the law usually, in many jurisdictions, if the factual disability did not occur before the legal disability, forget it. The legal disability had come first, that's what's preventing you from working, that's it. And so it's really important, especially with the doctor's treatment, because that's a condition of the policy. You have to be under a doctor's care. And if you can't establish that prior to that license revocation, you're going to have a major issue in many jurisdictions.
So, in this particular case with this financial planner, he ended up getting indicted by the SEC and then suspended with his license. And believe it or not, he had actually been having some treatment beforehand. It was known that he had substance abuse, and he was seeing a doctor, and that helped him. And Unum actually accepted that claim and paid him for 3 years. He was subsequently indicted for stealing thousands of dollars from his client. Unum continued to pay him for a 3-year period. What happened was, after 3 years, Unum denied him because his treating doctor said, you're in remission from your substance abuse. And as a result of that, Unum then said, well, look, you're suspended from your license. You can't go back to work. You're no longer factually disabled. And we're not going to pay you anymore.
Right.
And so to me, I read the case. I don't think he had an experienced lawyer representing him, because once his doctor said, you can go back into this high-pressure environment, we think you're in remission, he was done. I don't know why a lawsuit was filed against it, because in actuality, the Unum filed what's called a motion for summary judgment, and it was granted in favor of the insurance company.
Right, and I'll give the lawyer here the benefit of the doubt in the sense that maybe he tried to reach out to that doctor and explain, well, you have to understand his prior occupation was a high-stress occupation. If he goes back to that occupation, he's going to just relapse. This is just there's the question: is that an ongoing cause of disability? There's obviously the distinction of the anesthesiologist going back to the OR and being around all the drugs he was dependent on and all of that.
And that's a totally different situation of risk of relapse, because the the anesthesiologist, and we've handled probably 50, 60 cases like that, who says, okay, I'm in remission, but put me back in the OR, I'm going to get back on that drug, I can't go back in that environment. That's not a summary judgment issue, because risk of relapse is different. But risk of relapse for a financial broker who is stealing money from his clients is...
And the truth is, and I've dealt with this issue in cases before, when there is a investigation involving fraud of any sort, and we know as litigators, generally crimes of dishonesty and fraud, they can be presented in your litigation with the disability insurer if you go after them. That's not something that could be suppressed or anything like that in evidence. So the disability insurers know that. They start strategizing. They say, well, how can we avoid paying this $10,000, $15,000 monthly benefit? So I think he had probably a significant disadvantage there just from those facts alone. Even if everything else were true, the disability insurer is going to have a particular bias over the criminal actions that were kind of the underlying issue in the case.
I think the takeaway from this, and we already know this in counseling our clients, is the doctors have to understand what's at stake for this person going back. Meaning, can this person be a fiduciary to someone else in the future? If they stole once before, maybe they have a narcissistic personality where they should never be handling other people's money. And that's usually what I find. And so the treating doctors need to convey that, or the claim is going to get denied. And we've worked with many clients who unfortunately have had bad situations, been incarcerated, but they should never go back to that profession. And rightfully so, their license has been suspended. But we don't want them to see their benefits get suspended because of the fact that their doctors aren't documenting properly.
And I think you hit on a good point in terms of questioning how this case made it to litigation, because this is a case with the facts. It's a very high risk case. It didn't even get to because as you know, individual disability claims are generally adjudicated by a jury.
Right.
This didn't even get to the jury. This was presented before the judge, and the judge made the call that the case couldn't go any further and found in favor of Unum.
Right.
So I don't know if there were negotiations beforehand, but this is the type of case that as a plaintiff's lawyer, I would try to get in there with the disability insurer, try to work something out, present the facts in the light most favorable to my client in the best way we can, establishing based on the medical evidence that this person was factually disabled before any legal disability occurred, and try to get this worked out before it had to get to that next step.
Right. So if you have a claim with Unum Insurance Company, Paul Revere, or any long-term disability insurance company, feel free to give Caesar or any of our long-term disability attorneys a call. We represent clients all over the country. We always offer a free immediate phone consultation, and we look forward to the opportunity to speak with you.